right, welcome to this afternoon's public hearing. The purpose of the hearing is to hear and see if there's enough justification to remove the board's chairman, the board of the Housing Authority, Mr. Michael Bryant, from office due to misconduct or malfeasance or misfeasance. And the way we will conduct the hearing will be, I will allow Mr. Reed, who is the county staff attorney, to come and present the case before Board of Commissioners, and then we will give Mr. Bryant opportunity as well, followed by any questions that may be had by the Board of Commissioners. So at this time, I will call on Mr. Reed.
Good afternoon, Mr. Chair, Madam Vice Chair, Mr. Commissioner Davis. So I am, as you know, I provided you all a binder for documents that are related to this hearing, and so I'm going to go through it. I prepared a slide so that the members of the public could also see what you all are looking at as well. So let me start off with the legal standards. If you look on tab 1 of your binder, it starts off with a citation to OCGA 8352. The first subparagraph of that is subsection A, which summarizes that you cannot have a voluntary acquisition of an interest, direct or indirect, in a property, project, or contract connected with a housing authority project. And on subsection E, it says any violation of this code section equals misconduct in office. If you turn to page 2 of your tab, I've also provided you a copy of 8353, which is the authority that gives this a body the right to be able to remove a housing authority commissioner for misconduct in office. If you move to tab 2, members, I've also provided you a copy of section 2-56, which is our county code, which says that members of authorities can be removed for misfeasance, malfeasance, nonfeasance, which is subsection 3(1). Also, abstention from voting for a reason other than disqualification, which is subsection 3. I've also provided you on page 2 of tab 2 the definitions. Actually, it's page 3. If you look at the middle, under misfeasance, it gives the definition, the legal definition of what that is. In the summary, it's basically improper performance of an act which a person may lawfully do. Basically, you can look at that as negligence. Malfeasance is doing an act which a person should not legally do. That's basically something illegal. And nonfeasance is failing to do an act which they should legally do, which is basically an omission. And before I continue, I did provide Mr. Bryant a copy of everything that you all have as well, so he should be able to follow along with that if he has his book. So the first charge is related to misconduct regarding the Hack Deck project, and for purposes of our discussion, I'm just going to refer to the Housing Authority as HAC, so I don't have to keep saying that over and over again. So looking at tab 3, I'm providing you a copy of the minutes of the May 26th meeting. I'm going to go over it very quickly just to kind of give you some context. First, if you look at lines 29 through 33, just to call a meeting to order, a presentation by Dave Dixon, approval of the April 28, 2020 minutes, discussion and approval of monthly financials. There are all of the citations to the line. Discussion and approval of the Mount Zion bond documents, which is lines 45 through 48. Discussion and approval of the Regal bonds, defeasance documents, discussion of an engagement letter for Attorney Kenneth Brown, motion to go into and out of executive session, open discussion of employment issues with the executive session, call of a special call meeting to terminate the employment agreement of the executive director, and a motion to adjourn. I'm providing this to you for sake of context. June 23rd, they also had another meeting. If you look at tab 4, to summarize, there was a call to meeting to order with adoption of the agenda in the lines 28, 29. Approval of the regular and special call meeting minutes for those dates that are there, May 26, May 28, June 8. Discussion and approval of the monthly financials for May 2020. Discussion and approval of the resolution concerning Harmony at Ellenwood. That's on, if you turn to page 2 of your tab 4. This presentation on the HUG program. Discussion of staff interviews in response to the Donald Comer letter. Update on Regal Park closing. Discussion of hack restructuring, and a motion to adjourn. So, moving on to tab 5, and the reason why I brought those two together is that you'll see an invoice that's typed to Bryant Construction Group, and a handwritten words proposal over invoice, and handwritten Housing Authority of Clayton County over Bryant Construction Group. The total of that proposal is $30,390.61. And this is the copy of that for those members of the audience that are looking. And then if you turn to page 2 of tab 5, you'll see the June 8th, 2020 meeting minutes. This is the first meeting where the Hack building renovations were discussed. And if you turn, that's actually on page 2 of the meeting minutes. It says that Chair Bryant will be soliciting bids for painting. Again, I've copied those relevant minutes here for the audience to see. If you recall, the invoice was actually dated June 5th, but the minutes say that he's going to be soliciting them as of June 8th. Discuss building renovations for Hack, and also the July 28th minutes. That's also in tab 5 of your binder as well. I'm not going to go into the discussion on that. The first time that Hack actually dealt more with this was August 3rd. So after that June meeting, the July meeting, then August 3rd, you look at tab 6, there was a vote on the contractors to renovate Hack, which is in line 34. The vendor for the decks and handrail was Two Brothers Carpentry, and that's lines 40 and 41. The vote was 4 to 1. I'll keep on going with Bryant recusing, and the attorney for the Housing Authority at that time proposed a written resolution to confirm the project awardees. And well, there was supposed to be a slide that showed that actual meeting minutes, but I guess that's not there. If you look, oh, here it is, okay. So that is a copy for the members of the public. Lines 40 to 44 shows that Commissioner Harrison made a motion to accept the lowest bidder, Two Brothers Carpentry. Commissioner Lee seconded the motion and carried 4 to 1. Chairman Bryant recused himself from voting. Attorney Brown suggested a written resolution for the contract with Southern Siding and Two Brothers Carpentry to attach their final executed contracts. August 25th, which is tab 7, shows that the minutes of the August 23rd meeting was approved, and there was a unanimous approval of the resolution awarding decks and handrail work to Two Brothers Carpentry. That's lines 47 through 49, which I've provided a copy of those relevant meeting minutes for members of the public to see. Tab 8 is a copy of the Housing Authority contract with Two Brothers dated August 5th, 2020. If you look at section 1B, it cites that state law that I mentioned early on that says that no member, officer, employee, or authority should have a personal interest or obtain interest in the contract. It cites that language there. Again, I'm providing that piece of the contract underneath here for the members of the public to see. Section 1D references the property that renovated is 732 Main Street, which I've also showed there. The Housing Authority contract total sum was $30,390.61, consistent with the proposal that was provided. Again, showing the relevant portion of that contract for the public. And then the completion date of that under Section 2H was August 30th, 2020. Also within tab 8 is the Housing Authority Acceptance of Contractor form, which basically says that the Housing Authority has accepted two brothers to serve, it's missing two, but to serve as the contractor for renovation activities to the office, and it's signed by the Chairman Board of Commissioners with interim ED in parentheses. And this is a copy of that form which I referenced. And I believe that is page 3 in your book, Commissioners. If you turn to tab 9, the next is a transaction receipt from the City of Forest Park. It references a remodeling project at the Housing Authority, and the contractor is listed as Bryant's Construction Group, Incorporated. The permit was issued on November 23rd, 2020 to do the work. The amount that was paid for that receipt or that permit was $203.50. And again, that's a copy of the transaction receipt, which I've referenced for the public to view. Also on tab 9, there's a permit that also is issued by the City of Forest Park on November 23rd, 2020. Location, as you can see on there, says 732 Main Street. Lists the remodeling project at the Housing Authority, and the permittee is Bryant's Construction Group, Incorporated. Again, I've just made a copy of that top portion of the permit for the public to view as well. The next portion is in that same tab, the City of Forest Park plan check receipt, which shows the job address 732 Main Street. The owner is the Housing Authority of Clayton County. The applicant and contractor is Bryant's Construction Group, Incorporated, and the project description is listed as siding and deck repair. Again, this is that receipt there for the public to see. The areas where I'm talking about, and it's probably small from those who are sitting in the back, the applicant is mentioned right in the middle, and the contractor is listed right underneath that. You can see that it both says Bryant's Construction Group, and the contact for the contractor is Michael Bryant. Moving on to tab 10, there's an invoice from Bryant's Construction Group to the Housing Authority. The initial invoice is only for the building permit, and then there's a handwritten addition of building materials. And the building permit, building insulation is from Lowe's. The total is $757.65, which has a receipt attached, and a check check number 7984 issued from the authority to Bryant's Construction Group for $757.65. Again, that's the invoice there. As you can see, the typewritten amount for building permit, and then the handwritten portion, which I referenced earlier. The invoice, again, this is still in tab 10, has two signatures on that check. The top signature is the same as that on the Housing Authority contract and the acceptance of contractor form. Again, that's a copy of the contract there from the Housing Authority to Bryant's Construction Group in the amount of $757.65. And you see in the memo it says building permit and insulation. If you turn to tab 11, there are several invoices from two brothers to Bryant's Construction Group. The first is invoice 0073 dated 12/8/20 for $7,562.62. This is a copy of that invoice. The next in that same tab is invoice 70076 dated 12/22/2020 in the amount of $7,938.61. Okay, there we go. $7,938.61. The next is invoice 0078 dated January 6, 2021 for $14,890. That invoice is there. Again, it's from Two Brothers to Bryant's Construction Group. And the final one is invoice 0079 dated January 6, 2021 in the amount of $1,680. Total amount of all those invoices together is $32,070.61. If you could turn to tab 12, you'll see several checks from the Housing Authority to Two Brothers Carpentry LLC. The first is check 8004 dated December 9, 2020 in the amount of $7,562. There's a copy of the check here for the public. Also in tab 12, check 8016 dated 12/23/20 for $79,3861. And the last check, 8036 dated 1/12/21 in the amount of $16,570. The total amount of all those checks is $32,070.61. If you turn to tab 13, there is a check 8053 dated January 25th, 2021 in the amount of $7,000. If you look at that check, there's no invoice or minute entry that is referenced in the Housing Authority minutes, and there's no external reference on the check stub other than the check number. And the signature on the second line is the same as that on the contract and the previous check for reimbursement to Bryant Construction. And this is a copy of that check. Tab 14, these represent, for sake of completeness, minutes from all the Housing Authority meetings between May 2020 and February 2021 that I have not discussed or don't plan to discuss, just in case the board needs to reference anything. If Mr. Bryant comes back and says, well, it was referenced in these others, you have the other minutes here to be able to double check that. Charge number 2 is improper abstention from voting. If you recall back in tab 6, those August 3rd, 2020 meeting minutes referenced Bryant's recusal from voting, but there was no reason provided in the minutes for the refusal to vote. And then the meeting minutes from the August 25th meeting showed a unanimous vote to approve the resolution to award the contract to Two Brothers. That's also in tab 7. The last charge is basically a failure to respond regarding a matter of fiscal responsibility, and this is a violation of section 2-5631. So the May 28th, 2020 minutes show that, and this is in tab 15, that Wade Starr was terminated as the executive director of the Housing Authority. June 8th, 2020, if you go back to tab 5 in your book, there's notes in the minutes that says that they reference legal issues with the former ED. But the July 14th, 2020 insurance form that's for professional governmental underwriters, that's also referenced in tab 15, omits information about this claim. Section 2 of that form, which I've also cited here, says, are there any official or employee or does any official or employee have knowledge of acts, errors, and or omissions that might reasonably give rise to a claim or suit? And you see the check there is no. Section 4 of that same form, number 2, has any of the following taken place during the last 12 months? And you see there's no check next to reduction in staff, non-renewal of employment contracts, employee termination, or dismissals. There's nothing, any of those three at least would have referenced or been consistent with the minutes that were provided in the May and June meetings. On page 5, the signature on that insurance form is from Bryant, and I've provided a copy of that, and it's dated July 14th, 2020. I also provided a copy of the minutes for September 22nd, 2020, where if you look on page 2 of those minutes in lines 89 and 90, it says that there was a lawsuit threatened by the former executive director, and then I also provided a copy of the printout of the court case inquiry for the lawsuit filed in Superior Court by Waystar against the Housing Authority of Clayton County, and that was filed on October 21st, 2020. Also in tab 17, this is still responding to the matter of fiscal responsibility. There's an email from Commissioner Hambrick requesting a copy of the notice to the insurance company and their coverage decision on that claim. And I've provided a copy of that email to, from Commissioner Hambrick to Mr. Bryant with the CC to, I believe, several members of the Housing Authority. And the request was that a simple yes or no, did HAC notify the insurance company of the claim? If so, please provide written evidence of the notification and coverage decision made by the company. The response to that was from the Housing Authority stating that there were no responsive documents, and that response was on July 30th, 2021. Provided a copy of that letter from the attorney representing the Housing Authority. Notably, the first paragraph, it says that the Housing Authority has received your email request. After reviewing your request, it's been determined that there are no responsive documents. And then they cite the Open Records Act and the mandatory language for that. On August 4th, Commissioner Hambrick sent another request to Mr. Bryant to explain, asking him to explain the discrepancy on why there was no claim made against. And it says, my understanding at the time you answered the questions, no, that there were no pending claims or knowledge of any facts that would give rise to a claim, and I'll provide her signature so you know that's from there. And it said, if my understanding of these facts are correct, it's important to know why you chose to provide answers I think most people would see as untrue. I'm requesting that you provide an explanation for your action in this matter to me in writing within 3 days of the date of this email. And as of August 20th, 2021, there was no response to that. And I'm providing a copy of the email that was sent from Commissioner Hambrick to the Housing Authority board members, stating that, and in that second paragraph, I asked Mr. Bryant to respond to a simple yes or no to whether he had notified the insurer that the lawsuit had been filed. Mr. Bryant refused to answer that question. Secondly, I asked Mr. Bryant to explain why he made what obviously appears to be a false statement. Notably, Mr. Bryant refused to answer the question. So there are several violations of the state law and the county ordinance based on the information I provided to you. First is a violation of OCGA 8352A, misconduct in obtaining a voluntary interest in a housing authority project. As you recall, on August 3rd, the vote was from Housing Authority to award the project for renovation of decks and handrails to Two Brothers Carpentry. Based on that award, Bryant then applied for a permit to do the remodeling project at the Housing Authority listed the contractor as Bryant's Construction Group Incorporated, traveled to Lowe's to purchase building installation, submitted a reimbursement request to HAC for the $757.65, signed that check issued from the authority to Bryant's Construction Group in that same amount, and then, of course, failed to get approval from HAC for Bryant Construction Group to do any work at HAC property. And now, of course, he could not do so because that would be a violation of state law, because you cannot do work for the entity of which you represent. The other considerations that the board or others can investigate is that the initial proposal was written to Bryant Construction Group dated before the need was mentioned to HAC in June 8th. Invoices from Two Brothers were made out to Bryant Construction Group, but checks were paid for those invoices from HAC. A January 25th, 21 check for $7,000 was signed by Bryant and made payable to Two Brothers, but there's no record in the minutes for that expenditure. The contract approval was $30,390.61, but the total amount paid to Two Brothers appears to be $32,070.61, and there's no record that this extra expense was approved by HAC. But I want to note, importantly, that resolution of those issues is not relevant to what this board needs to consider today, because the issue is that Bryant voluntarily applied for a permit from City of Forest Park, bought supplies for Lowe's, and received reimbursement for those expenses on a project that it's undisputed was awarded to Two Brothers. The second issue involves improper abstention from the vote. Again, the meeting minutes from August 3rd showed a recusal from the voting with no reason provided. The minutes from August 25th show a unanimous vote to approve the resolution awarding a contract to Two Brothers. So you can't abstain from a vote at one meeting and then vote on the same issue at a later time. One or both of those actions are improper. As it relates to the third count, which is misfeasance, malfeasance, or nonfeasance, there's two issues. And the first is that there's misfeasance, malfeasance, or nonfeasance in failing to properly to report the claim. The meeting minutes show that May 28th, 2020, Wade Starr was terminated as executive director. They discussed legal issues with the executive director on June 8th. And then on July 14th, more than a month later, the insurance form completed by Bryant omits the claim, states there's no knowledge of any act reasonably giving rise to a claim, doesn't say anything about there being an employee terminated, and there's no supplement even provided to the insurance company after the September 22nd, 2020 minutes reflect that there was a lawsuit threatened by the former executive director. Second is a misfeasance, malfeasance, or nonfeasance in failing to respond to the Board of Commissioners or to a member of the Board of Commissioners concerning a matter of fiscal responsibility. This board has investigatory powers over the Housing Authority concerning matters of misconduct. I gave you that code section 8352. This board has appointing and removal powers over Housing Authority members under 8353, as well as the county ordinance. And Bryant received an inquiry by a member of this board on July 28, 2020, asking about handling of a matter of fiscal responsibility. And he never responded. And so, as you know, you all are each each elected to your individual commissioner districts, or in the case of the chairman, by members of the citizens of the entire county. And as the governing authority of the county, you all are vested with complete authority to investigate matters that concern Clayton County. And so when you appoint members to be on a board, you retain, or well, at least as long as the law allows you to remove them, you retain the right to look into matters involving their actions as appointees. Mr. Bryant was not elected, although he was the chairman of the Housing Authority Board, he was not elected to be in that position. And his power to sit on the authority is only given and can be taken away by this board's power. And so the willful, negligent, or mistaken complete failure to respond to a member of this board in his or her investigative capacity amounts to misfeasance, malfeasance, or nonfeasance. And if you, well, so today it's Commissioner Hambrick who had an issue that she wanted to investigate, but tomorrow it could be Commissioner Davis, it could be the chairman. And if you or Bryant or any appointee gets to determine that I get to determine as the appointee when I respond to you as the governing authority about a matter of which you have concern, then who is actually running the county, you or your appointees? And so if you condone or allow this kind of behavior, you are basically ceding your authority to have a control over all county matters and giving it to an appointee when it's you are the ones who have been elected by the citizens of the county to represent and govern all the matters of relating to the county. So after Mr. Bryant gets up and says his side of what is going on, should the board decide that he should be removed from the housing authority, the motion would be to actually order the removal of Michael Bryant from the housing authority of Clayton County because he committed misconduct in obtaining a voluntary interest in a hack project, improperly abstained from a vote without cause, and committed malfeasance, misfeasance, or nonfeasance in failing to respond to a commissioner's request for information regarding a matter of fiscal responsibility. And I have copies of that actual language for the board, should you want to have that for your reference after he speaks.
All right, thank you. All right, this time I'll call him Michael Bryant.
Thank you.
Good evening.
Good evening.
Is it possible that we could pump that up? I would like to just go through it because you did such a wonderful job with that. Some of that is great information on both sides. Thank you all for allowing me to have this opportunity for due process. I would like to start off by providing some context. Mr. Reed did his best to provide some context. But there is context that Mr. Reed failed to, and whether, I don't know if it's intentional or not, but it's missing. Why are we here? We are here because in May 2020, the Housing Authority of Clayton County board members, 4-1, voted to terminate the executive director, as he stated in one of his slides. We're also here because one of the board members of this commission decided to avenge the elections and the votes that those board members took. Her action, Ms. Hambrick's action, after Mr. Starr was terminated, was to go after one of the other board members that was on the board and intimidated her and asked her why she decided to vote to terminate Mr. Starr. That action landed Ms. Hambrick into the ethics hearing, of which, you know, the ethics board have no real teeth to sanction or hold Ms. Hambrick accountable for her actions, but that was yet something that occurred. Ms. Hambrick also, after that event, decides now to target me. I'm next on the list of people that voted to terminate Mr. Starr. And so we're here now because she wants to avenge Mr. Starr, and I need to respond to these allegations. First of all, the allegations of misconduct, malfeasance, and the vote that was taken in May gave the housing authority full discretion as to who the housing authority wants to hire. The board of the housing authority has the full discretion as to who they hire, who they fire, what contracts they want to engage upon, and what contracts they want to terminate. And so in the May meeting, we used our discretion that's given to us by Georgia Code. I want to also go over one little thing that Mr. Reed talked about, is my accepting checks from the housing authority. And this code right here, which is a Georgia code, it's Georgia Code, Title 8, Buildings and Housing, Chapter 3, Housing and General Articles, Chapter 1, Housing Authorities, Part 3, Housing Authorities Commissioners, Section 8350, Appointment and Qualifications of Tenure. I want to call your attention to one section of the code and ordinance that gives me the right to be reimbursed for any monies that was spent on behalf of the housing authority. The code reads in Section G, a commissioner shall have no compensation for his or her services, but he shall be entitled to all necessary expenses, including travel expenses incurred in the discharge of his or her duties. I want you to pay attention to that last section, is incurred in the discharge of his or her duties. So let's go back to the City of Forest Park and the building permits issues. The City of Forest Park, Mr. James Shelby, Director of Community Development, had a meeting with me at the Housing Authority. He noticed that there was work going on at the Housing Authority. He asked me, did I have a building permit for the work that was going on at the Housing Authority? I indicated to him that we did not have a building permit, and because we were doing repairs, technically, a building permit is not required for repairs. He communicated to me, said, you're correct, that is for repairs. However, this is a historic building, and this building have a lot of visibility, and you're right across the street from my office at the City of Forest Park. And I'm going to recommend and strongly require you to get a building permit, because technically I could put a stop work order on you if I choose to, but I'm not going to do that. What I'm going to do is require you to come and get a building permit for the work that's being done on this building. Now, his requirement to me is to get a building permit. Fortunately, and every time that I've been on this board, I've done nothing but use my skills and expertise to benefit the board and to be an asset to the board and not a degradation. So his requirement of me to get a building permit for the work that was being done, I immediately responded to that as he required to go get a building permit. So therefore, I'm the owner, president and CEO of Bryant's Construction Group. I'm a licensed general contractor in the state of Georgia. I have the credentials and the abilities to pull a permit for the best interest of the housing authority. And so I elected to do that out of the sense of urgency and also a demand that was made to me by Mr. Shelby from the City of Forest Park. Now, as it relates to the owners with that application, I serve 2 rows, in this case 3 rows I was the interim director for the Housing Authority. I was also the chairman of the Housing Authority, and I also had the credentials to pull a permit on behalf of the Housing Authority. And so, as you all would love for members of the boards that you appoint to use their skills and expertise to benefit that authority, that's what I did. I used my skills and expertise to benefit the Housing Authority. There's not one single red cent that was from that $700 check that was written to Bryant's Construction that was not a profit. It was a reimbursement. And based on this Georgia code here that I've just read, it gives me the opportunity and the rights to be reimbursed for any expenses in the discharge of my duties. I need you to be very careful in your consideration and understand that it was the discharge of my duties that I had to the Housing Authority to, one, make sure we're compliant with the laws, two, to make sure that the building is safe and good repair, and three, to make sure that our building is not going to, and that work is going to be something that we'll all be proud of and become a curb appeal effect as opposed to the dilapidated building that it was before. So we used our judgment accordingly to Georgia code, to this Georgia code. As it relates to the misconduct and failure to respond to Ms. Hambrick's emails, we responded to Ms. Hambrick's open records requests. Every single open records request that we received from Ms. Hambrick was responded to Ms. Hambrick within the given period of time, the 3-day period of time that the law requires. Mr. Ken Brown, our attorney, is here to attest to that we responded to every single open records request. The email that was sent to me was an individual email sent to me, not an open records request. After council conversations with council informed me that that is an email request, not an open records request. I'm not obligated to answer and respond email requests. I am, however, obligated to respond to open records requests. That's what I did. So the act of responding to an open records request is something that is well within my rights and responsibilities to do. The act of responding to an email request is discretionary, and I use my discretion to not answer that question based on conversation and advice with our counsel. Ms. Hambrick has asked for open records requests repeatedly to the Housing Authority after the termination of Wade Star. Before the termination of Wade Star, Ms. Hambrick asked for no open records requests because everything was good as long as Mr. Starr was employed with the Housing Authority. The minute Mr. Starr is no longer with the Housing Authority, then Ms. Hambrick decides, I need to have open records requests. As a commissioner and as a friend of Mr. Starr, she knew very well that Mr. Starr was threatening to sue the Housing Authority and have litigations with the Housing Authority. Some of her emails that she asked for was treading very close to me giving up information that she could give to Mr. Starr to assist him in his litigation. So one of the other reasons why I chose not to respond to Ms. Hambrick after her email request is she's asking for open records requests and asking for information. I know she's a friend of Wade Starr. What's going to prevent Ms. Hambrick from giving Mr. Starr all the information that she's asking for from me and give him the opportunity to be victorious in his litigation with the Housing Authority? What's preventing that act? So I didn't trust Ms. Hambrick's ability to not maintain a professional a commissioner's position and perspective. And I didn't trust that she didn't use the proper judgment. She wouldn't use the proper judgment to have that information confidential because it's in the best interest of the county and the authority. My instincts tells me that Ms. Hambrick is going to take all the information that she's been given to share it with Mr. Starr, which is going to put the housing authority and the county in harm's way. So, yes, I failed to respond to you, Ms. Hambrick. Yes, I wasn't going to give you information for you to continue to disseminate that information to a person that you knew was potentially filing a suit with us. So let's go back to the August 3rd, or the May 20th meeting and the August 3rd. On August 3rd, I was both interim director as well as chairman of the board. When we voted to select the contractors for the renovation of that building, it's in my best interest to not be involved with the selections process because I was also serving as interim director. I chose to recuse myself, which is not in the minutes, but it was a statement that I made to my board members. If I'm a part of the bidding process, it's in my best interest not to be a part of the selections process. Therefore, I can't be accused of routing and influencing decisions that potential other contractors who bid that job and didn't receive that job would get upset that they didn't receive the job and know that I was also a part of the selection process. That's a valid argument to have. I chose to take the high road to recuse myself from the selections process because I was involved heavily with the bidding process. So I would think that you guys will see that as a mark of character as opposed to a degradation of duties and responsibilities. So with that, I'm going to pause for a moment and I'm going to give Mr. Brown, our attorney, an opportunity to discuss the open records request that was repeated from Ms. Hambrick. At one point, Ms. Hambrick was asking for open records requests almost every other month. It got to the point where we sent her invoices for those open records requests. She paid one, but not the others. So we have done everything that we can do within the law to respond to open records requests. She just didn't happen to like the responses and the information that she received. So she decided to backdoor this thing and come to me and send me an individual email thinking that she's gonna catch me with some kind of wrongful answer, something that she can use against me. And I would not allow anyone to try to backdoor a proper procedure. If you want information, the proper way of doing it was open records requests, not sending me an individual email so that I can give you information once again to a potential plaintiff in a case that I was going to be a defendant on. With that, I'll pause and give Mr. Brown an opportunity to speak on, with your permission, the open records.
Mr. Brown, are you present?
Yes,
Please come forward.
good evening, ladies and gentlemen of the board. I appreciate the time. My name is Ken Brown. I'm counsel to the Housing Authority. A couple of, words. It's important that you all understand that I represent the authority. I don't represent Mr. Bryant. I don't represent any individuals, any individual board members, any individual officials with the Housing Authority. I represent the corporate entity. Second thing is, I do not represent the Housing Authority with regard to any issues with Wade Starr. That's just a decision that I've made, and not only that, but because there's current pending litigation between the former executive director and the Housing Authority, I will not have any comment on any of that litigation. I've advised everybody associated with the Housing Authority to do the same, not comment on that litigation or anything dealing with Wade Starr. I am here to provide some information regarding the open records requests that were made from Commissioner Hambrick. Did assist in putting these together and gathering documents and talking to the various different officials with the Housing Authority. On June 26, 2020, we received the first open records request from Commissioner Hambrick that requested first, any formal evaluation of Wade Starr's job performance by the Board of HAC in which Brenda Harrison participated. Second, minutes of the meeting in which Ms. Harrison and the other board members of the board voted to terminate the employment of Wade Starr. Third, minutes of any meeting where evidence was presented to and or a vote was taken by Ms. Harrison and the other members of the board of the Housing Authority to terminate Wade Starr. Fourth, an engagement letter entered into between HAC and its attorneys at Bloom Parham LLP. Fifth, invoices and copies of all checks made out to Bloom Parham LLP, who were the attorneys representing the Housing Authority in that litigation. Sixth, total value of the employment agreement entered into between the Housing Authority of Clayton County and Wade Starr from the date of the termination to the end of the agreement. Seventh, the HAC bylaws and Commissioner's Handbook. We did on June 26th respond to Commissioner Hambrick in full and provide those documents. Secondly, on July 22nd, 2020, the Housing Authority received a second open records request from Commissioner Hambrick, asking first, invoices from and checks made payable to Bloom Parham LLC from June 1, 2020 until July 17, 2020. Bear in mind, I mean, these are asking for the invoices from the lawyers who are representing the Housing Authority in current litigation. I mean, I'll call that out of the ordinary, required a great deal of redacting, certainly just numerous issues with attorney-client privilege in those matters. And in our response, we did decline to provide certain documents and redact certain documents because of the attorney-client privilege. Third, second, it asked for, please provide the specific legal authority for redacting a portion of the engagement letter entered into between Bloom Parham and the Housing Authority of Clayton County. As I specified, a great deal of that information is attorney-client privilege, but this is an example of the type of, I guess, information that's not permitted under the Open Records Act. Not only does it not have to be disclosed, is there an exception for attorney-client privilege, but this is asking for specific legal authority. That's an interrogatory, a question asking for information. That's not what the Open Records Law is. The Open Records Law is an opportunity to get public records, not an opportunity to make inquiry about certain issues. So with regard to that question number 3, please provide specific legal authority for not providing the documents you stated in your July 2nd, 2020 email were not subject to disclosure, referenced below. Fourth, communications between Brenda Harrison and any HAC board member or member of the Clayton County Board of Commissioners related to the modification or termination of the employment agreement entered into between Wade Starr and the Housing Authority. Fifth, communications between Brenda Harrison and any HAC board member or member of the Clayton County Board of Commissioners related to the hiring of Thompson Hine or Bloom Parham LLC. No documents were provided with regard to questions 2 through 5. We did respond in full to that request with responsive documents. On June 17th, 2021, just approximately a year later, an open records request was received by the Housing Authority from Gail Hambrick, asking for all RFP, RFQ, RFPs, all announcements, all bid documents, tabulations, score sheets, invoices, all checks, and all correspondence between HAC staff or board members and any individual company who performed any work on the property. Second, it asked for all HAC board meeting minutes where any discussion or votes were taken related to the improvements on the property. Third, copies of all directors and officers' insurance policies which provided coverage to the Housing Authority of Clayton County from January 1st, 2020 to December 31st, 2020. We did respond. These were voluminous documents, hundreds and hundreds of pages that we disclosed, and did in fact send that on June 17th, 2021. We received an additional open records request approximately a couple weeks later, dated June 28th, 2021. In this one, It asks for any correspondence or documents which show that Hack provided notice to any insurance company of any potential actual claim or lawsuit between 2020, January 1st, 2020 and the present. We did in fact disclose and provide documents subject to attorney-client privilege in response to that. We also received email. So at this point, these were 4 relatively standard open records requests. The 5th request was dated, an email dated July 28th, 2021, asking questions, and specifically saying this request for information is not being made under the Open Records Act. It is being made pursuant to the authority granted in Section 2.563 and 2.33 of the County Code of Ordinances, as earlier discussed by the county. The fact of the matter is, neither one of those statutes require the disclosure of anything. They have nothing to do with any disclosure of any documents. So I do think it's incorrect to say that either one of those statutes creates an obligation of the Housing Authority to provide documents. It simply doesn't. Nevertheless, we treated that as an open records request, made a response on July 30, 2021, indicating that we had no such documents because we were not required to respond. Lastly, we got another email making a request, ultimately ending with, in order to determine if further action is required, I'm requesting that you provide an explanation for your action in this matter in writing to me within 3 days of the date of this email, from Gail Hambrick on August 4th. That's just simply not something that the Housing Authority is obligated to do. There are ways to get this information, depositions and such, in existing litigation. You can't just send an email and demand this stuff. So we did, again, respond to the letter dated August 9th, 2021, and nevertheless disclose documents. That's the information I have with regard to the Open Records Act and the documents that were provided. I'm happy to answer any questions if y'all have them. Otherwise, I turn it back over to Mr. Bryant.
Let's hear again from Mr. Bryant right quick, and then we'll open it up for questions from if any of the commissioners should have any. And before he comes, those of you who are here for our regular business and zoning meeting, I would ask that you have a little patience as we wrap up this hearing. Mr. Bryant.
Thank you, Mr. Chairman. Let's go back to the issue of my filling out the application for the insurance and the charge of fraudulently responding to some of the answers, the answer no in particular that you saw on the slide. You saw the date of that date of that particular email or slide, that was in July of 2020. We didn't receive notice of any type of lawsuit officially from Mr. Starr's counsel until October of 2020. And so if I answered yes on that application and I've never received any type of formal notice of service of a notice of a litigation, then I would be committing fraud. And I would be out of my mind for lying on a document that we hadn't been served. So we got to understand the chronology here. July comes before October. In July, I filled out an application. I answered no, truthfully. In October, I was served with a litigation. So on an application of a renewal policy in July that I've not been served on, in June, conversations were there, but in July, there was no service. I can't be accountable or responsible for something that's going to come to me in October and July when it comes down to a renewal of an application. Again, I'm serving as both chairman of the board and interim director. As far as the claim that Mr. Reed made about I wasn't elected to be the chairman of the board, I wasn't elected by the citizens in Clayton County, but I was elected by the board members that serve with me on the Housing Authority. Just as we vote for a vice chair, as treasurer, assistant secretary, just as you all vote who's gonna be the vice chair of this particular board. That's well within our discretion and our rights and responsibilities as board members. That's given to us through codes and ordinances from the county and the state. We have that obligation to do so, and we did it in good faith. So, let me sum things up for a moment, just in case I need have some extra time. I'm not begging and pleading to keep a volunteer position, ladies and gentlemen. As you see, I do run my own company, and I do it well. But I never take a job in Clayton County. If you want to do some research, go to community development here in the county and ask Mr. Igiche to pull up the records of any building permit that Bryant's construction group has pulled working in the county in the last 5 years. You will see there's 0. I do not accept projects in the county where I live because I'm also a housing authority commissioner, and I don't want anybody talking about perceptions of impropriety. And I don't want anyone thinking that I'm going to use my political affiliations with the housing authority to curry favor with community development to pull a permit. That's character. That's my character. What I will not do, Ms. Hambrick, is allow you to impugn and attack my character and associate me to be a corrupt individual like so many other people in your circle. We won't do that. But I will respond to a legitimate question with a legitimate answer.
Mr. Bryant, let's make sure we're not,
Yes, sir.
let's be a little more respectful.
Yes, sir.
Okay.
So, once again, the application answered no. That's July. The service of a pending litigation occurred in October. Matter of fact, you guys have that in your packet that Mr. Reed gave you as well. So, there's nothing that I did to defraud the insurance company. There's nothing that I did that was wrong in my answering the questions to a policy renewal. And guess what? The policy was renewed. It's still renewed. And it's still active because we responded. Anything after November 15th, there's some checks that you saw that was written, or November 16th rather, of 2020. Anything after that, Michael Bryant was no longer the interim director and the chairman. We had hired a director, and I brought that director to this board to introduce her to you all. And so those particular checks, there's a check for $7,000 or $7,000 that he's alleging that had no backup. That wasn't under me because I was no longer in charge of the day-to-day operation. And I had no reason to be at the Housing Authority office on a day-to-day basis because we've hired a person to do that job. And so that person's job was to provide that type of oversight and bring documents to the board of commissioners for us to approve and sign off on any type of a check. So as you see, the checks has 2 signatures. There's some with my signature on it, and Denise Ziegler's signature, who's our executive director. You see some checks that has Brenda Harrison's signature and Denise's signature on it as well, because Brenda Harrison was our treasurer. Our authority has a 2-signer policy. We have 3 signers that's in our bank, that's registered with the bank to sign checks, to keep checks and balances properly. So any check that you see my signature affixed to also have another person's signature affixed to it as well. And both of us reviewed those documents and agreed that that was a legitimate check to sign off on in the best interest of the Housing Authority. So anything that Michael Bryant has done, any action that Michael Bryant has committed, it's been given to me in the form of resolutions and Georgia code. As far as reimbursements for checks, I have that full right to be reimbursed because I was in, as it says, the discharge of my duties. So with that, I'll open it up for any questions that you all have and be happy to answer.
All right, are there any questions from board members for either Mr. Reed or Mr. Bryant?
I do have one. Who owns Two Brothers?
Pardon me?
Who is the president or owner of Two
It's
Brothers?
a gentleman by the name of Dewan White. I'll tell you how I came to know Mr. Two Brothers. When we were attempting to start the process of the decking material, I went online along with the HUD coordinator at the time, Ms. Rashonda Duggan. Both of us went online. We happened to go on the Lowe's website, and we see this decking material. It's called composite decking. That means it's a no-rock material, and it gives the building a whole longer life than we've had before. And so I went to Lowe's and talked to someone at the pro desk person at the time. I asked her, hey, what contractors do you have that buys this material on a regular basis and installs this materials on a regular basis? And she gave me 2 phone numbers. Two Brothers was one, and there was another
Okay.
company.
Great.
And so I contacted Two Brothers to give him an invitation to bid on the rehab of the building.
Thank you. I have a question for Mr. Reed. You gave us in tab 2 the code. In 4B, it begins to talk about what a county board authority can do. And it says, except where permitted by law and where the contract for goods or services does not exceed $250,000. My question is there anything that a board member can be contracted to do?
So Mr. Bryant is correct in that if he were traveling somewhere or if he was expending some sort of money as it relates to his job duties, he can get reimbursed. That is not contrary to the law. Where the difference is in this is that he, as the interim director, was subject to the authority of the board, just like using the COO as an example, or the chairman probably is a better example. This board gives directives and says chairman shall follow the directives of the resolution, he's authorized to carry out the blah, 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 blah. That's what his role was. So when the housing authority said Two Brothers was the contractor, when the person from City of Forest Park came and said, hey, I need you to get a contract or get a permit, his role should have been to go to Two Brothers to get that, as opposed to doing it himself. Even though, and again, I'm not suggesting that he did this out of any ill intent. It's just he didn't do what he was supposed to. He cannot have an interest in a project as an officer or member of the authority and be in compliance with state law. And I'm not suggesting any ill intent, or it's just a mistake. Probably just he didn't understand or didn't know that that was present. But both the contract as well as state law prohibited him from using his own business to get that permit. He would have had to go to Two Brothers and ask them to come and do it.
Okay.
No, are you going to ask the same question?
I mean, if he wants to respond, it's
Yes, sir.
yours.
Go ahead.
As it relates to my acquiring a building permit, the resolution that we voted on, there's language in that resolution that gives me the ability, that's authorized by the board members who voted affirmatively for that resolution. It gives me the ability and the opportunity to do whatever is necessary in the best interest of that project to make sure that that project is completed properly and is done in good taste and good faith. And so that resolution alone, the language in that resolution And that language is in section 4 of our resolution that gives me that authority. I was also serving as an owner's representative with the city of Forest Park.
What does that mean?
An owner's representative means, as an interim director, I represent the best interest of the housing authority. And in other words, I have power of attorney, therefore, to act in the best interest and make sure that the housing authority is in safe arms and we're doing things properly. So as an owner's agent, as well as I've just happened to be a contractor, I had those dual responsibilities. And that was well within my rights to do so. As Mr. Reed said, nothing was done in bad faith. Nothing was done with any corrupt intentions. It was only done to allow the housing authority to be a benefactor of the skills and the license and the credentials that I particularly have in the best interest of the authority.
Thank you. So Mr. Reed, I guess if nothing's done intentionally, does that now take the term malfeasance out and we have to deal with misfeasance?
It could, but it doesn't matter what that resolution said. His resolution cannot allow you to violate the law.
Understand.
I gave you that code section on purpose because it says no commissioner or employee shall voluntarily acquire any interest, direct or indirect, in any project or any property included or planned to be included in any project or in any contract or proposed contract in connection with any project. Black letter law. So it doesn't matter what the resolution says. It doesn't matter whether he had he thought he could do it as virtue as the director. The law says he cannot. The documents clearly show that it was done not on behalf of the housing authority, but done on behalf of Bryant's construction group, in which he is obviously the owner of that, and for that, that's the reason why that constitutes misconduct as a matter of law.
Any other questions?
I guess one comment, Chairman. For me, to me, there seems like there's more information that needs to be had here. And it almost seems to me that this is a situation where a complete audit of the financials should be taking place here. Because this is not just totally about Mr. Bryant, in my view.
Yes. No. Did you have something, Ms. Hamburg?
Yes, I would like for our attorney to go back over the points that you made as far as removal is concerned.
So, again, there are 3 issues. Not all 3 have to be found, but there are 3 that are presented. First is the misconduct under state law, that voluntarily acquiring an interest. Under subsection E of the statute I provided, that constitutes misconduct. 8353 gives you, as the Board of Commissioners, if you find that that actually occurred, you can remove him from the authority on that issue alone. The other issues related to the state law, to the county ordinance, related to the response to the commissioner's inquiries, those have already been spelled out as far as the emails back and forth. You can decide whether that was constitute misconduct, malfeasance, misfeasance. You can make a decision on that. That's the one. The other one is the abstention. Even though he abstained from the first vote, he voted in favor of the resolution at the second vote. That doesn't require an audit. It's just a matter of looking at the minutes. You can still have an audit done. Nothing, the other information I provided as far as the other checks and all that kind of stuff, you can look into that if that's your desire, but that's not anything you need to do prior to determining whether him voluntarily obtaining an interest in this contract constituted misconduct. Was there anything else you needed me to address?
All right, so if there's no other questions, is there a motion on the floor?
Let me say this, well, okay, yes, there is a motion. The motion is to order Michael Bryant be removed from the Housing Authority of Clayton County because he, number one, committed misconduct in obtaining voluntary interest in a HAC Housing Authority of Clayton County project. Number two, improperly abstained from a vote without cause. And number three, committed malfeasance, misfeasance, or nonfeasance in failing to respond to a commissioner's request for information regarding a matter of fiscal responsibility.
All right, the motion is in favor of removal. Is there a second? Is there a second to the motion? All right, hearing none, the motion fails due to the lack of a second, but I will say this, I do think that there should be a closer look at everything that's been proposed. There's serious allegations here, and I think there should be a follow-up to the allegations. So with that being said, this hearing is concluded.
Before we do
You would
that.
like to make a statement?
Yes, I would.
Commissioner Hambrick.
I'm disappointed in this board because we have not followed our own duties and responsibilities to the community. We have removed people for less than this. We removed someone a month or so ago for not attending a meeting. We took off a person, last year for non-complying as far as filling out a form. That's an annual form or whatever. I mean, little things that we've done, we've taken people off. We took several people off the Development Authority in the last 2 years for whatever. I can't even remember what. Maybe I think missing a meeting. And here we are with information that has been given to us by the attorney that this person has the malfeasance, the misfeasance, and all this misconduct and all, and we fail to do anything about it. So I'm very disappointed in this board.
Well, let me just say this. It just didn't pass as far as removal at this time. If there's further information, and I will ask for an additional audit or a unbiased investigation of this, there is some room for concern. I'll give you that. But also, it's kind of troubling that we would bring these are serious allegations, and you're the complainant, and you're going to be the jury too. And I know that's the way this is set up as a hearing from somebody who we appointed, but I would rather have facts gathered from an unbiased third party as well as an audit, whether it goes back 5, 10 years or whatever, because we don't need to piecemeal. We just need to go through. If there's serious issues at the Housing Authority, I say let's get to the bottom of it and handle it all at the same time. So nothing precludes us from having another hearing or making another motion, whether to remove him or anybody else.
Well, Chairman, is there anything we can do right now to pursue an audit? I'd say for at least the last 7 years.
Well, this is was a public hearing because we are closed out of it, but that it would be something that I'll bring up to the board for your recommendation and consideration.
Let me ask this question. What will be the purpose of an audit when we've been given information,
Well,
accurate information, and
Well,
all
the audit-
documents, signatures, and everything? And now, I don't see a need for an audit. If we're
Well,
not going to do anything and not fulfill our duties and all, forget an audit.
Okay, well, you're entitled to that opinion, Ms. Hambrick. Okay, so interest of time, we're going to conclude this hearing. We're going to take a 2-minute break. We'll come back at, 6:51, 2 minutes, and then we'll reconvene our regular business meeting / zoning hearing. Thank you.